Hello, my name is Kristine Kalnina, and I'm a senior associate in the Reed Smith Energy and Natural Resources team based in our Dubai offices. My practice focuses on dispute resolution, predominantly within the construction sector. In today's podcast, which forms a part in a wider series of ENR podcasts, I will be exploring the enforcement considerations in Dubai arbitration process, tracking its development over time and providing some analysis as to where we are at now in August 2017. The endgame for any binding dispute resolution process, be it a court litigation or an arbitration, is turning that piece of paper containing the judgment or the award into tangible money in the bank account. Regardless of the merit of the aggrieved party's case or the strength of the moral entitlement, the ability to enforce the judgment or the award against the assets of the sinner would be the number one consideration for us lawyers before any step is taken in the legal process. Once upon a time, not so long ago, the United Arab Emirates was not a signatory to the New York Convention. For those who do not know, the New York Convention is an international agreement that allows for arbitration awards, as distinct from judgments of the national courts, issued in one signatory country to be enforced in the territory of all other signatory countries. As of now, 157 countries and 40 foreign territories and dependencies have given effect to the New York Convention, and that covers the vast majority of the globe. In 2007, the United Arab Emirates has also ratified the New York Convention, which represents a quantum leap for the enforcement of UAE-based arbitration awards around the world and the enforcement of foreign awards here in the UAE. To put this into context, I was personally involved in an attempted enforcement of an arbitration award issued by the London Maritime Arbitration Centre before 2007. The amount at stake was substantial, and one of the respondents had significant assets in Dubai. Therefore, it was decided to give it a shot and try enforcing the award through the Dubai courts on the basis of the enforcement provisions in the UAE Civil Procedure Code. The advocate presented the petition to the local judge at the court, and the judge lifted his eyes off the papers with a rather puzzled look on his face and asked a very deep and meaningful question. "What do you want me to do with this?" Needless to say, the case went down the hill very quickly from there, and the arbitration award never got enforced in the UAE. Since the advent of the UAE's ratification of the New York Convention in 2007, the legal landscape looks very different, and many foreign awards have now been successfully enforced through the UAE courts in various emirates. In parallel, under the patronage of the ruler of Dubai, the courts of Dubai International Financial Centre, or in short DIFC, were developing its own English law-based legislation and two-tier court system as an alternative to the local Dubai courts. Initially, since the enactment of the DIFC courts law in 2006, it was understood that the DIFC courts only had a jurisdiction over orders, judgments and awards that touch and concern the geographical territory of DIFC. However, then, in 2014, in Maidan and Banyan Tree case, some bright spark decided to try their luck and applied to the DIFC courts for a ratification order of an award issued by the Dubai International Arbitration Centre, or DIAC for short. Basing his reasoning on the somewhat vague wording of the relevant provision of the DIFC courts law. To the astonishment of the legal community, the DIFC Court of First Instance accepted that the wording of the DIFC courts law is indeed wide enough to cover arbitration awards that have no direct relationship to the geographical area of DIFC, and the seat of the arbitration can be located anywhere in Dubai and indeed elsewhere. The DIFC Court of Appeal, being the highest authority on the matter, upheld this position. This then became what was subsequently known as the Conduit Route. Basically, instead of approaching the local Dubai courts for a ratification of an award and getting bogged down in lengthy and historically unpredictable three-tier court proceedings, awards, both UAE and foreign, could now be ratified in DIFC courts. The ratification order of the DIFC courts could then be executed directly through the execution department of the Dubai courts, pursuant to already existing Dubai legislation. And then the Dubai courts would have no say in interfering with the arbitration award. The order of the DIFC courts is also similarly executable in other emirates of the UAE through the route of first execution stamping the DIFC order in Dubai courts and then executing it elsewhere as a Dubai court judgment. The DIFC Conduit Route therefore quickly became the route of choice for enforcement of arbitration awards, both domestic and foreign. And truth to be told, it was only a matter of time before the Dubai courts, or the powers that be, reacted to what was effectively a gradual encroachment by the DIFC courts on the jurisdiction of the Dubai courts. So in June 2016, a decree number 19 of 2016 was issued, establishing a committee called a Judicial Tribunal. And the task of this tribunal includes to determine conflicts of jurisdiction between Dubai courts and DIFC courts, if conflicting judgments exist, determine which judgment prevails, and propose rules and regulations to avoid conflicts in the future. Fair enough. This development was welcomed in the legal circles and by and large generally went unnoticed and didn't draw much attention. That is, until the later part of 2016, when the Judicial Tribunal started issuing its decisions. Let's take a step back and give this latest development a bit more context. The Judicial Tribunal is set up to have 7 judges, 3 from the DIFC courts, 3 from the Dubai courts, plus the President of Dubai Court of Cassation, who has a casting vote in the event there is a gridlock amongst the other judges. Without reading too much into the nature of the appointments, it is not difficult to notice that 3 of the judges are likely to be inclined to vote one direction, towards the DIFC courts, and 4 the other direction, towards the Dubai courts. Lo and behold, the first round of decisions of the Judicial Tribunal have been released, and they do not look good at all to the DIFC court's jurisdiction to ratify domestic, namely onshore Dubai, non-DIFC arbitration awards. The case number 1 of 2016 between Daman Real Estate and Augur Dubai concerned an enforcement of 2 domestic arbitration awards against Daman in DIFC. Daman commenced parallel legal proceedings in the Dubai courts in an attempt to nullify the award and frustrate the DIFC courts process. Both the Court of First Instance and the Court of Appeal of the Dubai courts declined jurisdiction on the basis that the award by then was already in the process of being enforced by the DIFC courts by way of winding down Daman. Daman, however, referred the matter to the Judicial Tribunal, and to everybody's astonishment, the Judicial Tribunal decreed that the case is to be remitted for trial back to the Dubai courts, and the DIFC courts should, quote, cease from entertaining the case, unquote. Very little other guidance was, however, provided. It is also noteworthy that the Daman versus Augur case was not a true conduit jurisdiction case, because Daman was a DIFC registered and DIFC territorially based entity, and the DIFC courts would therefore naturally have jurisdiction over this entity. The only real link to the onshore Dubai was the seat of the arbitration. An almost identical decision was also made in the second case decided by the Judicial Tribunal, which is, you guessed it, number 2 of 2016, between Dubai Waterfront and Chenshan Louis. In this case, both parties were registered onshore Dubai, namely those were non-DIFC entities. Therefore, this was a true conduit scenario. But the decision of the Judicial Tribunal was exactly the same. The DIFC courts were instructed to cease from entertaining the case. It is also interesting that in both of these cases, the 3 DIFC judges dissented and did not agree with the conduit jurisdiction being taken away from the DIFC courts, but both decisions were passed nevertheless by the majority of the Dubai court's judges. The decisions of the Judicial Tribunal have made it clear, however, that the enforcement of foreign awards and judgments has not been currently affected, in the same way as the enforcement of domestic awards. And this was expressly confirmed in the decisions of Daman and Waterfront by the Judicial Tribunal. Further decisions were also issued in cases numbers 3 and 5, being Marine Logistics versus Wadi Voroya and Gulf Navigation versus DNB Bank, that both upheld the claimant's entitlement to enforce against the respondent's assets in mainland Dubai through the conduit route of the DIFC courts. The position therefore currently seems to be that it is more prudent to stay away from the conduit route as far as the domestic onshore arbitration awards are concerned for the time being. But this route remains open for foreign awards and judgments. Many questions currently still remain outstanding. Was it a policy decision that domestic awards can no longer be enforced through the IFC courts? And that would be a fair question considering how the Judicial Tribunal is constituted. Or is it still worth trying to distinguish the two cases from the future cases in some way, on a technicality? It is also noteworthy that the Man and Dubai Waterfront cases both had parallel proceedings in the Dubai court. What if there are no parallel proceedings? Is the DIFC court then allowed to entertain the case? What if it is a foreign award or judgment, but there are parallel proceedings in Dubai courts? Then what? Is it a temporary stay? Does it matter what the outcome is in those proceedings in the Dubai courts? There is no clear answer at the present time, and speculation runs rife as to the future of the conduit route and its possible limitations. As all of this was happening, in September 2016, which is only a few months after the decree establishing Judicial Tribunal was passed, the DIFC Dispute Resolution Authority and Dubai International Arbitration Center signed a Memorandum of Understanding for the purpose of enhancing strategic interests, research and cooperation between these two bodies. The MOU by its nature is not binding, but the object of the cooperation is curious indeed. And the cooperation is for the purpose of, and I quote, the expedited recognition, ratification and or enforcement of DIAC arbitration awards by the DIFC courts, which is exactly the conduit route that was just apparently shut down by the Judicial Tribunal. So watch this space. In other news, in early 2017, DIFC issued a Decree number 1 of 2017, which stipulates that if anybody wishes to challenge an award, they would have to put up a security for the full amount of the award, which would then allow the claimant to draw on that amount in the event the challenge fails. In such a case, the challenger would also have to compensate the claimant for all its legal costs expended in resisting the challenge on an indemnity basis, which is a much higher threshold than the standard costs awarded in most other cases. The DIFC courts have therefore indicated loud and clear that they have no patience for trivial challenges against perfectly valid arbitration awards. That being said, what is and is not a credible challenge for enforcing domestic non-DIFC arbitration awards through the DIFC ratification process remains a bit of a mystery at the moment, considering the simultaneous but conflicting developments regarding the conduit route. This concludes this podcast. For further information on Reed Smith Middle East practice areas, including energy and natural resources, corporate and financial law, please visit www.reedsmith.com via the link in the information boxes below. For information surrounding the context of this podcast or for any UAE arbitration or litigation queries, please feel free to contact me or any other member of the UAE litigation team.